Answer the question. You want answers?
I think I'm entitled.
You want answers?
I want the truth!
You can't handle the truth!
Hey everyone, welcome to question 3. And this question dealt with evidence. And here you had 3 questions, and I think it was key to use time as a strategy. Now, every time I see a question on evidence, I want to do that question first. So if I have 3 questions, I'm going to go and I see evidence, I'm going to do that question first. And so in this case, I would have done this question, evidence first, and then I would have done the contracts remedies question, and then I would have done the first question in that order. Why? Because I could see this question right here could take easily 65 minutes. So let's go ahead and just get into this. And again, I'm just highlight the important points here. And number 1, it says that the court properly admit the hospital intake form. So let's talk about that. So of course we talk about relevance, logical relevance, and it seems like there is some kind of tort action here. How is this relevant? I wanted to address that. It may prove damages. It may show that Peter was experiencing some kind of emotional condition when he made those statements. So I'm going to say it does meet the definition, the elements for logical relevance. So legal, let's skip that. Best evidence rule, no facts indicate that it was not the original, and this does not seem to be an issue. I'm going to just address that very briefly. Authentication. Okay, so let's see now. Double hearsay. So let's talk about that. So when you have something like this, both layers, so the hearsay must be separately admitted. Now it seems like there's 2 levels here, and it seems like Pete's statement is one, and then the other one is the hospital intake form. So at first glance, it may be that the hospital intake form is performed out of duty and in the course of business, out of routine. However, the Pete statement is not routine, and it's not under the regular course of business, because of course every patient is going to say something different according to how they feel. So both statements have to be discussed separately. So let's talk about the first layer here, Pete's statement. So Peter's like, hey, told Nettie the nurse that he struck the windshield with his head, and he was still in a great deal of pain. So is that hearsay? It seems like it is, and I'm not going to get too much into that. Let me see if there's anything here. Okay, non-hearsay exceptions, excited utterance. I'm going to of course discuss that. Present sense impressions. I'm going to discuss that as well. Now the difference here between these two, these could be very similar, but the present sense impression usually involves like seconds or even minutes between the event and when the words are spoken. So here I'm going to say that the statements by Peter, I mean, that could have been hours because of that head injury. So I'm going to say it's not admissible under present sense impression. And feeling to determine the timing of the condition, he was in pain. You can make an argument there that was a condition. He made that statement as he was experiencing that condition. I'm going to say that the court might focus on the accident itself. So I'm not going to admit it, and I'm not going to admit it under this exception here. Then of course you have the then existing mental, emotional, or physical condition. Physical condition. He was experiencing pain. Statement made for medical diagnosis or treatment. You can definitely discuss that. I'm going to say the statement was properly admitted. That's the first layer. Second layer, the hospital intake form. And I think most of you guys said, hey, business record. That's awesome. In the course of business. So that statement by that intake form was properly admitted. Okay. Now question 2, what does it say? Peter's testimony about Aaron's statement at the accident scene. Okay, so Aaron, what did Aaron say? Aaron, what are you saying here? Okay, so let's see. She says, according to Peter, she says that she was in a hurry to make a pizza delivery and that she ran the red light. Okay, so relevance, logical relevance. So the crux at issue here seems to be whether Aaron ran the red light. and thus cause the accident. That's what we're looking at. So yes, it is going to be logically relevant. Legally relevant, it is going to be highly prejudicial, because look what she says. She says, I ran the red light. Highly prejudicial. However, the danger of the jury arriving at an improper conclusion is crucial here. So that doesn't seem likely that a jury might arrive at an improper conclusion, because of course Donna and Aaron testify. So this statement is probably does meet the criteria under legal relevance. So it's not going to be blocked by that. Okay, hearsay, see rule above. And notice how I don't put the whole rule there again, just see rule above. Okay, non-hearsay, impeachment under PSI. And PSI stands for prior inconsistent statement. So there, I want to see the attorney attack the witness on the stand. That's what I want to see. I want to see an impeachment. Okay, so let's see what are the rules here. So it says a prior inconsistent statement will be met even if it's extrinsic evidence if the witness is given an opportunity to explain or deny the statement, and number two, the adverse party is given an opportunity to cross-examine. Okay, so here's where those movie scenes come in. So you want to see a party that is just going to grill that witness on the stand. Very dramatic. I want to see that. And then, so it seems kind of like the witness is being attacked. And that's what I want to see. And let's see if we had that here. So there does seem to be inconsistent statements on the part of Aaron, because on direct examination, she says that she had the green light. And then there's another statement that is not made under oath that Peter makes. And according to Peter, that Aaron said that she ran the red light. So now we must determine whether Aaron was attacked as a witness on the stand in order to meet the elements here. And Aaron is never asked by Pete whether she made the statement or to explain or deny it. And also the statement, the inconsistent statement is made while Peter is testifying. And so of course again, Aaron is not given the opportunity to deny or explain the statement. And so the order was not met. The order needed, the elements, the rules needed under the prior inconsistent statement rules were not met. So I'm going to say no. That statement was not properly admitted under the prior inconsistent statement. Okay. Party admission. Let's talk about admission. So I think the important thing here is that the person must be a party, and I don't think Aaron was a party. She was an employee of Donna's Pizza, and the facts do state that Pete sued Donna. Let me see, Pete sued Donna's Pizza. So Aaron is not a party, so they can't come in. And of course you have the other exception here. Let's see, statement by an agent of party opponent, and there then you can make a strong argument, and there that statement can come in. When the claimant is unavailable, statement against interest. Aaron was in court, so she's not unavailable. Excited utterance. Okay, maybe present sense impression. Okay, so under present sense impression, I'm going to say again, not under that rule. Okay, present state of mind, she was in a hurry. There we talk about intent. So I'm going to say that the statement is admissible. And I'm going to, of course, it was for the exceptions that I stated. Okay, now let's go on to question 3. Pete's testimony about Donna's statement at the hospital. What is that statement? Well, let's look at the question first. Peter's statement about Donna's statement at the hospital. Okay, cool. So let's go back. And what did Pete say that Donna said? Okay, told him that Donna's Pizza would take care of all his medical expenses. Relevant. Now it said logically relevant. I'm going to say that it is, because we're trying to see whether Aaron ran the red light. Was it okay? Legally relevant. So there we must consider the public policy rules there, considerations, and an offer to pay medical bills that will not be admitted under public policy consideration. And here, according to Pete, Donna, that's exactly what Donna said, that she would take care of the medical expenses. So that's not going to be admissible here. Presentation, I'm going to skip that. Hearsay, non-hearsay. Non-hearsay, impeachment under prior inconsistent statement. Again, PIS. So again, I want to see Donna being attacked, okay, by Pete. Now it says here that the statement can be used by Pete to impeach Donna. And Peter's testimony that Donna visited him in the hospital and told him that Donna's pizza would take care of all his medical expenses. So again, we must have the proper introduction. We must follow that order. Okay, so on direct examination, Donna testified that the pizza was not responsible. However, Peter did not give Donna the opportunity to explain or deny Pete's statement. See, there's a statement there by Pete, and he's saying that Donna made the offer to pay for all medical expenses. Now, keep in mind that Donna was given the opportunity to explain whether she made the offer to pay the hospital bill. The question is there in the facts. However, look at this. The facts do not state that Donna was told that a prior inconsistent statement was being asserted by Pete. So instead, she's merely asked, hey, did you ever make any offers to pay? So the allegation is not included in that question. And remember that the person on the stand has to be given an opportunity to either explain or deny the statement. Okay, so let's talk about the statement here. And what is that statement? It's the allegation by Pete that Donna said that she would pay for all the medical bills. So, because it seems like we have two different statements there, and I'm going to say that no, under the prior inconsistent statement rule is not going to be admitted because it doesn't follow the rules. Unavailability, statement against interest, Donna was available, hearsay exceptions, excited utterance, and that's the conclusion there. So I hope this helped. I wish everyone the best. Until soon.